rebuttal time. All right, so we're ready for Pinellas County versus Grant.
May it please the court. Good morning, my name is Kelly Vicari. I represent the appellant Pinellas County. I would like to reserve 3 minutes for rebuttal, please.
Okay,
This is an appeal of the trial court's consolidated order granting a motion for summary judgment in favor of the appellee Green Energy and denying Pinellas County's motion for summary judgment and a final judgment quieting title for Green Energy. This case centers on a judgment lien that is held by Pinellas County. The former owner of this subject property in Pinellas County was Crest Capital. Pinellas County gave a loan to Crest Capital through its community development program, and Crest Capital failed to pay that loan. Instead of pursuing a foreclosure, the county sought a final monetary judgment against Crest Capital. And a judgment was obtained in July of 2010. It was in excess of $3 million. The county then recorded the final judgment in the public records and
Can I ask a question? Is it conceivable that a reasonable reader of the judgment that a reasonable reader of the judgment would read it to indicate that it's not the address of the judgment holder of the county, but it's rather the address of the county's attorney? I mean, it says it's the attorney's address. It says it is directed to the party's attorney. Pardon me, it's directed to the defendant to give a fact sheet not to the party, but to the party's attorney. Isn't it reasonable to presume that the reader would infer that that's not the address of the party, and that is the lien holder, but instead is the address of the lien holder's counsel?
Well, Your Honor, I'm not sure what a layperson might perceive that to be, but the way.
Why a layperson? Why not anybody?
Because the Pinellas County was the plaintiff in the action, and its attorney is.
No, I'm saying any reader.
Pinellas County
A
Attorney's
lawyer,
Office. Well, I think it could be.
so a reader could be not a layperson, a lawyer, but not have, intimate knowledge of the geographical locations of all the buildings in which all the departments of the county reside.
Correct, Your Honor, but I believe that reference to the Pinellas County Attorney's Office tells the reader that that's a department of Pinellas County. Pinellas County is the plaintiff, Pinellas County Attorney's Office.
Is your argument that it would be any address? Could it be the sheriff's department?
Well, no,
What
Your Honor.
if the judgment had directed the sheriff's department or the administrator of the county jail, which presumably is in the sheriff's department, and, it said, send something to the county sheriff? Would that comply with the statute?
No, Your Honor, because the sheriff is a separate officer. The sheriff is not part of Pinellas County. He's a separate constitutional
How
officer.
about Parks and Recs? Is that part of Pinellas County?
Your Honor, I arguably would say yes, that the county, because this is a unique set of circumstances, right? The case law that's cited by the appellee all pertains to.
Any property owned by Pinellas County?
Well, it's property owned by Pinellas County, yes, but again, I would argue that yes, that would comply because it is property owned by Pinellas County. Pinellas County was the plaintiff, but that's not the situation that we have here. What we have here is actually 315 Court Street is the address provided in the judgment, which is the address of the Board of County Commissioners. The lower court took judicial notice of that, and the county's attorney's office sits in the same location.
So if I understand your statutory argument, you're hanging everything on the word contained.
Yes.
This judgment contains 315 Fourth Street, and since that is within the four corners of the judgment, that satisfies the statute. Let me take that argument and put all the chips in and take it to where I think it could lead. By the lights of that notion, that as long as it's within the four corners of that judgment somewhere, the correct address of the plan, why couldn't you have a judgment that says, and this would be ridiculous, I recognize, but something along the lines of plaintiff, Pinellas County, whose address is not 315 Court Street, shall recover a judgment in an amount of $3.9 million. Doesn't that satisfy the statute under the lights of your argument? Even though it positively disclaims that that's the address.
Well, Your Honor, I think that under our interpretation of the statute, the way it's written, that yes, that would comply because the language of the statute merely says contained. It does not place restrictions. It does not place
What does
mandates.
contained mean in the context, though? Like, Judge Lucas's example would comport with one meaning of the word contained in isolation, which is somewhere in there. But is there more to the word contained in the context? In other words, indicate what the lien holder's address is? Or do you think that's not a permissible reading, or that's a reading outside the ordinary meaning of contained in the context?
Right, I think that is going beyond the plain and ordinary meaning of the statute. That is then adding requirements to the statute. It wasn't written to say needs to clearly state the address of the lien holder within, a sentence that reads XYZ. I mean, the legislature could have made it very specific, but it merely says contained within. So adding on.
Let me ask you this.
Yeah.
There's another means by which the lien holder can satisfy the address requirement. That, I guess this could go both ways, interpretively speaking, but it says the affidavit method would state the address. So you can just throw it in there anywhere. If it just happens to appear in there in the judgment, then that's okay, but if not, you have to state it. But it is the fact that the legislature provided an alternative means in which there's an affidavit stating it, does that suggest anything with regard to the purpose of requiring it to be in the judgment or an affidavit, other than just being there somewhere? Does it suggest that it's supposed to indicate to the reader that this is the lien holder's address?
Again, by the plain meaning of it, it just says that it has to be stated. The way that I have read it and that my client has interpreted it is that portion of the statute allows for, if there was a mistake in the final judgment, you're able to rectify it. Obviously, in this case, the county did not file an affidavit.
With Judge Lucas's hypothetical,
Admittedly ridiculous example.
well, I'm currently taken to it. So, with Judge Lucas's example, would that comport, if an affidavit said, this, what was it, 315, what's the address in here? So, I get, 315, if the affidavit said, the 315 Court Street, Clearwater, 33756 is not the lien holder's address, would that comport with the requirement that the affidavit state the address of the person?
Well, I think if we're getting into the nitty gritty, I think in that scenario, it would lend itself more to the argument that you're not stating the address if you're specifically saying this is not the address. But that's using a different word. That's saying state the address. In the provision that we're talking about here, it's contained within.
So the alternative means you have to state it. You have to, in the affidavit, you have to spell out, or you have to indicate that this actually is the address of the lien holder. But in the judgment, if it appears in the judgment, it can be just an oblique reference. Just happen to be there for alternate purposes. Okay.
Yes, Your Honor. Okay, I will continue on. So yes, so to touch on that again, the judgment does contain the address. I know we've talked about the hypotheticals. Again, that's not the scenario that we have here where this is the address of Pinellas County. It's a Pinellas County building. The administrator sits there. The county attorney's office is located there. The Pinellas County Attorney's Office represents Pinellas County. So given this unique factual scenario,
It is unique. I mean, I don't want to beat this.
Right.
It is unique only insofar, I will tell you, I can't fathom why that first line didn't have the address of Pinellas County. I mean, every civil judgment starts plaintiff whose address is shall recover. This one, it doesn't say Pinellas County, just says Pinellas. So it sure looks like somebody did a drafting error. What you think?
I agree that it could have been written more clearly.
It looks like someone made a drafting error.
However, the lien would still comply with Florida Statute 55.10 for those reasons. And when I say unique, I also mean that we're dealing with a county government.
Well, yeah, because the statute contemplates a person, not
Correct.
an entity that could have multiple addresses.
Correct. It does state person.
I mean, it seems like as good a choice of address as anything. As opposed to the Parks Department.
Correct, correct.
Or the Sheriff's Department.
That's correct, Your Honor. And like I said, with the case law that was cited, Hot Interiors versus Bostock, the 721 Southern 2nd, it's a 4th DCA case from 1998, that was cited by Appelese, and that really echoes all of the case law, where the address of the lien holder was completely absent from the judgment. It was not in there, and only the address of the attorney was present, which is not the factual scenario we have here, where the address of the county attorney's office is one and the same as the lien holder, Pinellas County.
Can you walk me through your arguments? Sound a little loud, sorry. Can you walk me through your argument that 95.192 sub 1 doesn't apply because the Applebee's here, Green Energy, was the plaintiff and not the county? The county was not the plaintiff. Walk me through that.
Yes. So Florida Statute 95.192 is titled Limitations of Actions Adverse Possession. And the section specifically titled Limitations Upon Acting Against Tax Deeds. So in this case, Green Energy was the purchaser of the property at a tax deed sale. They hold title to that property in fee. The county is not acting against that tax deed. They're not acting against the title for legal ownership or anything to do with that. We are simply saying that our lien survived issuance of the tax sale. It hasn't been extinguished. Presumably, if Green Energy failed to pay taxes for several years and the property went up for tax deed sale again, the county would have the possibility of obtaining
So if
surplus.
I understand the discrete point of why you're making that argument, is that that statute, that language should not even be considered.
Yes,
Okay, I'm gonna push
and
back
I can
against,
go back.
I'm gonna push back against that a little bit.
Okay,
All right. You are, I think you are correct, only insofar as who the party plaintiff was here. It was indeed Green Energy and not Pinellas County. But why does that matter in the context of a Chapter 65 quiet title action where the thrust of the whole action is to determine who would have competing claims and interests in the property and to definitively dispose of those interests? The only reason that it matters that Pinellas County has a putative judgment lien is so that it could assert a claim on the property. And so in that context, since it's within a quiet title action, the court has to consider who could potentially bring these claims, and one of them would be potentially by Pinellas County.
and Your Honor, potentially bringing a claim that would not bring us within the Florida Statute 195.192.
That's missing
Okay.
what I'm trying to say here.
I think I am
I'm not doing a
making a
good job explaining. So in every quiet title action, you're necessarily going to consider all statutes, all the parties that are before the court, you consider all of their potential common law claims and statutory bases to assert a claim in the property. Okay? That being so, you necessarily have to unpack what those claims would entail in order to definitively expose them. You can't quiet title without considering the bases of the county's claims, and one of them would be 95.192. So why is that off the table? Why shouldn't we? Flip it around. Wouldn't the court have erred if it had failed to consider a statutory basis for the county to assert a claim on its property?
Okay, Your Honor, I'm going to try to answer this correctly
Sure.
for you. So the issue with the quiet title action is that a different section of Florida statutes, section 197.552, provides that the county's judgment lien, when it's not satisfied from surplus of a tax deed sale, it shall survive. So for purposes of a quiet title, the county's lien survives. That's where that statutory,
But that's not, I don't know if that's answering Judge Osh's question. I mean, that's a separate question.
right, and then coming back though, that's why 95.192 is not applicable in this case. It says that when a tax deed has been issued, no action shall be brought by the former owner or any claimant under the former owner. Again, there hasn't been an action brought
Let me ask
by
you,
the
it has
council.
an action, so to take
Ownership.
Judge
Correct.
Lucas's.
Right, it's like who owns it?
Are you saying that because the quiet title action was brought by Green Energy, this doesn't apply? So and maybe I'm misunderstanding Judge Lucas, maybe I'm misunderstanding you, but what sounds like by your argument, it doesn't apply in this case, but if separately Pinellas County foreclosed on the lien, it would apply.
Yes. But that is what I'm trying to say.
Because you also said there's another reason it doesn't apply, because they're not an owner or former owner. But you're saying your argument would not apply, because then they would be bringing an action, a lien foreclosure.
Correct. So if the county was bringing an action to foreclose on this property, if the county was,
What Judge Lucas is saying, isn't that tantamount to the same thing? If you're quieting title and you're saying, no, I have a claim against the property. because-"
no,
Okay.
no, because they're
So
the ones.
action means action, and your argument applies in this case, because it's quiet title, action brought by Green Energy, but it's, if it was a separate action brought by Pinellas County to foreclose the lien, then it would be an action brought by them.
Correct. I think I'm understanding, like, yes, in this case, again, they brought a quiet title action. Pursuant
So
to
so
one
in other
ninety,
words, let's leave aside the issue of whether they're a former owner. Let's assume for the sake they're a former owner. I don't know that I agree with that, but let's just assume that they have no right, their lien is worthless, right? Because they can never bring an action.
I'm sorry, who's,
Pinellas County's lien, they're, leaving aside the question, just assume for the sake of discussion that they are a former owner, claimed a former owner. What you're saying is, well, you know, this doesn't apply when someone brings a quiet title action, but essentially Pinellas County has a worthless lien because they can never bring an action to foreclose it, right?
well, I mean, in theory, yes, however, like I said, there's scenarios where this lien still attaches to the property and it's valid for 20 years.
Wait, let me stop you
Yeah.
because you've now confused me about your argument. And I'm gonna tell you, you're hitting right up against your
Okay.
10 minutes, so I'm gonna give you time to answer my question. And then you can do what you want with the rest of your time. I thought you said, you cited the statute that says the lien is good for 20 years, but now you've turned around and said you can't foreclose on it because this 4 years applies? If Pinellas County wanted to foreclose on it? Is that what you said?
Well, Your Honor, I think that, yes, that you read it both ways because we're not bringing the action.
Well, wait, you want to say you've got a lien that's good for 20 years, but you can't foreclose on it. Is that what you're saying?
I'm saying, well, it still attaches and we would still be entitled to surplus funds in the future if there
I'm
was.
sorry, what?
It would still attach to the property, however, if there was another situation in the future where there's surplus funds, because the governmental lien survives, you would still be entitled to those surplus funds, even if you're not
Surplus
bringing an
funds
action
from
to
what?
foreclose.
From what?
From the same as what happened in this case previously, where there's tax certificates that are sold, and then buyer purchases the property at tax deed sale, there's surplus, and then it goes to governmental liens that might attach to the property.
Okay, all right, so you're at 3 minutes, you can do what you want with it.
Okay.
Maybe it would be a good time to talk about your other argument why this section doesn't apply. Because Pinellas County is not an owner or a former owner.
Right, and that is correct. The county is not a former owner of the property, and it's not a claimant under the former owner of the property, the former owner being Crest Capital. So-
What would be an example of a claimant under the former owner, like an assignee or something like that?
Well, within that statute section, they talk about grantees, persons that hold patents. It's the way that it reads, it's designed for situations where an entity under the claimant would have an argument for title or possession of the property. We know that also because it's within the adverse possession section. Just very briefly, I just wanted to state this again, that the 95.1921, the argument is that does not extinguish the county's lien because it is not the scenario that we have here. It's not applicable. The county has not brought an action in this case. So again, just that is wholly inapplicable. So with that, I will reserve whatever time I have left.
All right, thank you.
Your Honor, a bit of housekeeping. Mr. Brooks is here, an attorney representing Mr. Grant. We did not expect Mr. Grant to make an appearance because he's stipulated out of the case.
Right.
But Mr. Parks would like to have 2 minutes and I'm fine with that. And then I'll take the rest of our time. If
Okay,
that's-
you're all right with that?
Yes, yes.
Okay, all right.
Good morning, Your Honors. My name is John Parks. I represent the appellee Dennis Grant. As Mr. Massey indicates, Mr. Grant stipulated out of the case, and that stipulation was incorporated in the judgment in the trial court. Perhaps in an overabundance of caution, we would point out to the court that no one has challenged that in the brief, and any right to challenge it has been waived, and that however the court may decide the case, we would respectfully request that it affirm that portion of the judgment that deals with Mr. Grant.
Okay, thank you.
So, thank you.
Thank you, Mr. Parks.
That wasn't even a minute, so you're good.
Okay, thank you, Your Honor. I appreciate that. So may it please the court, my name is Marie Tomasi. I'm here on behalf of Green Energy, the appellee. And I'm going to start with the judgment lien, whether it's actually effective, because that's.
Is a claimant, is Pinellas County a claimant under the owner, or is it a claimant against the owner? It's a claim against. But what does under mean to you?
Well, the path that gives, can you hear me okay?
Yes.
I'm having a little feedback in my
Are you
head.
fine?
Okay. The path by which the judgment lien holder gets in line is right through Crest Capital. Without Crest Capital, without the judgment against Crest Capital, then Pinellas County obviously wouldn't have a claim. So
It's not like a standing in the shoes scenario. They don't have a right under the rights of Crest, that they just have a lien against their interest, right?
they have an unattached, Pinellas County has an unattached lien against any property if they have a lien at all, which is, I think, why you all started there. That's a pretty much starting point. But if they have an effective or valid lien, then it's only because of the judgment that's against Crest Capital. And that would be a claimant, the county would be a claimant under that former owner, Crest Capital. Otherwise.
Are you using the term under in the sense that is often used in granting title, which is that there was a predecessor interest through which you now have an interest? Is that your take on what under means here?
Yes, Your Honor, and those are the words from the statute, any claimant under the former owner. Otherwise, you wipe out pretty much anybody except literally the former owner. So what does it mean to say we're under the former owner? It would severely narrow the statute, and so why are the words there? But going back to where the court started this morning, there's the threshold issue of whether the county even has a valid lien, because 55.10 has very detailed instructions for how you create a judgment lien.
But is it your position that it should contain a different address, that this is the wrong address?
No, our position is that it should state the address of,
That's only the affidavit that has to state it.
it
The-
should
the, judgment
contain.
lien.
I'm sorry, Your Honor, you're right, let me be
I
more
mean, what's wrong
precise.
with this judgment? How should it have been written to comply with the
should-
statute? I guess that's what I'm trying to find out, because it contains the address.
It does contain the address by the mere coincidence that the county attorney's office is housed at
Well,
350
it's a lucky coincidence then for them.
Court Street. Well, maybe, maybe not, because if you read the statute 5510, it says a judgment does not become a lien unless the address of the person who has a lien is contained in the judgment. And what is the purpose for that? If you look at the judgment that we actually have, a stranger to this case, just some Joe Blow off the street who needed to know whether they want to buy a piece of property, maybe, for example, they have no way of knowing the address of the judgment holder. They only have the address of the attorney. This is why those
Well,
cases
the
get
attorney and the
reversed.
judgment holder have the same address, and you know who the judgment holder is because of the style of the case.
Well, you know the name of the judgment holder, but you don't know the address. And the statute says it has to contain the address.
Well, it
And
does contain the address, but I think what I don't want to put words in your mouth, but it seems like what you're arguing is it's not clear enough that this is the address because the attorney's name is appended to it.
because nothing tells the reader, this is the address of the lien holder, that this is the address of the judgment holder, I should say. And that's,
But the statute doesn't say you have to preface it.
No,
It just says it has to contain an address.
of a person who has a lien,
And the person who has the lien is Pinellas County,
not the county attorney,
right?
not the county
But
attorney's
the county's address
office.
is in there. Are you saying that's not the county's address?
Oh, no, we're not saying that's not the county's address. The trial judge recognized that, but
I mean,
I'm
I think-
saying,
I understand, I think I understand your argument, but I'm, you know,
The cases you cited that don't seem very supportive because in those cases, for instance, the lawyer's address was substituted for the judgment holder. Here, that can't be said in this scenario. The attorney's address was the judgment holder's address, so you can't say it was substituted for. It doesn't say in care of. It doesn't say, you know,
I understand what Your Honor is saying, but I
in care
would,
of an attorney in a separate address. It's
I
just-
would say it is substituted for, because
well, if they have to name a person to go with that address, wouldn't the county attorney make sense? I mean, who are they gonna name? The mayor or somebody on the county commission? I mean, is that a point you're making, that because the county attorney's name is affixed to it, it makes it confusing? As opposed to some other county official?
No, Your Honor, I think it's simply a matter of statutory language and the fact that the state attorney's office, the county attorney's office, pardon me, is not the lien holder.
I think your better argument in that regard is that the statute, by saying the judgment shall state the name of the party and it has to contain the address, the statute necessarily creates a context where there's some communicative link between who has the lien and what their address is. And here, what we have, the communicative link is send a fact information sheet to the county attorney whose address it is. which
Right.
Do two different things. I think that's the only way I can understand the argument here.
I'm sorry, Your Honor, that I didn't say it as clearly because that's what I'm saying. What is the purpose of requiring the address of the,
I'm not looking for purpose,
Right.
I'm just saying, using the language of the statute, that's the
Agreed.
only way I can interpret your argument to make sense, and I'm not sure
It's that clear, but.
well, I'm going to move on in that instance. In that instance.
And
In that
I know you want to move
instance.
on, but could we move back? Could you tell me, what cases you cited, because it's very likely that I forgot about them, if there were some, in which there was a scenario, and this is a unique scenario a little bit, because under 197, you know, the county's lien, according to the county, survives, but, is there, where claimant under the former owner, let's see if I can think of a hypothetical, and you can tell me if there was a case you cited, a claimant under the former owner, so it's an owner of the property, subject to a tax deed, and that claimant was someone who had a lien against the property. And they were deemed to have been a claimant under the former owner and had their right to bring an action extinguished. Not someone like an assignee of the owner or something like that, but someone who had a claim against the owner's property, a lien.
I
Do you have a case?
I understand your question, Your Honor. We do not cite a case for that fact situation. I'm assuming this does not arise on a daily basis, simply because when you research it, there's not a ton of case law under 95.192 sub 1. But what's clear, and this is what I think is important, is let's just assume, for the sake of argument, that the county did have an enforceable lien. Then they're right that under 197.552, title tax deeds, the county's lien of record is, or survives, I should say, the issuance of the tax deed in its initial issuance. But it doesn't say anything in 197.552 like for the normal 20 years, for any particular time period. It just says it survives. It's a tax deed, it's a lien. So then it's also subject to 95.192 sub 1, which is a statute of repose, which is intended to let people who buy tax deeds know that after 4 years, that property's theirs. If
But
nobody's,
it's an action against the deed.
I'm sorry,
I mean, the statute is titled limitations upon acting against tax deeds.
right?
So I don't understand how, I mean, this, if you wanna challenge the tax deed, you've got 4 years to do it. Otherwise, the person owns the property. That doesn't take away a lien that's on the property. I mean, I'm not understanding how the fact that you now have title through this tax deed that cannot be challenged after 4 years, how do you get from there to, oh yeah, and we're gonna eliminate any liens on the property?
Because to bring a claim under the former owner with a judgment lien, by way of a judgment lien, against the property is a claim against the rights conveyed in the tax deed.
Well, I'm not sure I agree with that that's a challenge to ownership. I mean, if you want to foreclose on the land, all of the county has said, now we have 4 years to foreclose. I wouldn't have read it that way, but they seem to read it that way. They just want to keep their lien for 20 years. I guess, so if there's another tax deed, they get a surplus.
But
I'm not sure I understand their argument.
but
I'm
nothing,
not sure I understand how you get from, you can't challenge the deed after 4 years to NPS, nobody can have a lien, nobody that had a lien that survived, it's not gonna be nobody, because they're all extinguished unless it's a municipality or the county, how it extinguishes those liens.
well, because the tax deed has been issued, the statute 95.1921 or sub 1 expressly references 197.552, the tax deed statute, and then provides no action shall be brought. Well, how else are you going to enforce a lien
Wait,
against?
what are you referring to now? I'm sorry.
Oh, that's okay. I'm sorry, I'm not being clear. I'm saying section 95.192 sub 1,
Right,
limitation of actions, statute of repose, referred to as
Right.
both.
no action against the
Expressly.
deed can be brought.
I'm gonna
I mean,
try,
the title of the section is limitation upon acting against tax deeds, and when you look at all the case law, there's not much, but you look at it, I mean, I don't think any of them involve liens. It involves claims of ownership, adverse possession, things like that. In other words, who owns this piece of property?
but nevertheless, if what the county is saying is that they have a lien against the property,
Right.
but they can't enforce it, because
Well,
if they,
I think that's what she said.
That was,
Yes,
but that was a
because-
concession to my argument that was a concession to my hypothetical argument that if action means action to foreclose. But you're answering a question from Judge Kelly about what in general this statute of repose extinguishes. It extinguishes all liens or just extinguishes the right of a claimant under the owner to challenge the tax deed.
well, I think it's pretty broadly written. It says, when a tax deed has been issued under 197.552 for 4 years, no action shall be brought by the former owner of the property or any claimant under the former owner. It doesn't say no action for this, for that, not for this, not for that. It's,
Oh, but we have to
very-
look at it in context.
yes,
And the context is a limitation upon actions against tax deeds.
yes. Well, acting against tax deeds. So if the county's saying, well, we have a lien against this property because of this judgment from,
If
that
the
we,
lien doesn't affect who has title to the property.
I'm not arguing that, is what I'm saying is, how do they enforce the lien? It's not self-executing. They're going to have to take some actions.
Which comes back to the point that you're gonna apply a title action, the whole point
Exactly.
is to ascertain what the claims
And-
are to this property.
And that's what I'm saying is the county wants to keep their, what I'm gonna call a smudge on title, this dirt mark on the title.
Cloud, we call it a cloud.
Well, okay, sorry, real property lawyers everywhere, because you're right. I don't know these things that.
Smudge is good, but-
I like smudge, but I'll use cloud, because, right, a cloud on title is a little more professional than smudge. But they can't
Maybe
do
it's
it.
supposed to like a small cloud.
But, so they want to keep their cloud on the title, but it can't, but they're also saying, but you can't clear it.
Yeah.
You can't do anything about it. So it's just gonna,
Because you can't convey, you
Can't.
can't borrow on it, it's effectively.
so who's gonna ever want to buy a tax deed and wait 20 years?
Well, you could pay off the lien.
Well,
I
you
guess it's
could,
the county's
sure, you
decision.
could. Why would you buy the tax deed though, if it's $3 million lien they're claiming? So.
That's an interesting question, but probably not pertinent, but why was the tax? I mean, someone bought a tax lien with a lien, a tax deed on property with, to property with a lien on it.
Well, it's a potential lien on the property. It's
Right,
not been
right.
executed on. You know, this is a judgment lien, not specific on the property from a foreclosure. When the county wants to attach it to some property that Crest Capital had at the time, they have to go through a whole series of steps to execute on the judgment. So they're going to have to take an action, which they can't do, pretty clear
According to
under this statute.
95-192.
It's
So
about-
really you're anticipating, what you're saying is this, because they can't bring an action.
Well, that's why the trial judge, I think, referred to it as extinguished, because what can they do with their cloud?
Well, they're saying it's, you call it a cloud, they call it a lien.
But they can't enforce it. What can they do with it? If they're gonna have to take an action to enforce it, and it's been more than 4 years.
Well, I think that I presume the attorney from the county is gonna stand up and say that there's another reason why that 4-year statute of repose doesn't apply, and that's because they're not an owner or a claimant under the owner.
Right, but that's incorrect, because the only way they have any claim against this property is through the judgment they have against the former owner. I mean,
think
they,
they're claiming against the former owner.
right, but their claim
Not
against
under.
the county here,
But so, they're claiming against, they're not even claiming against the owner, really, they're now, their claim is against the owner's former property.
it's
Right.
through their claim against.
Well, but, so that's another aspect, that's another difficulty for your argument, interpretive argument, which is that their claim is against property owned by, what was the name, the C word, the name of it?
Clear Cap, I'm sorry, Crest.
Crest.
Mhm.
Their claim, right, I mean, their claim was against them, right, generally. But for the purposes of their argument that the cloud should remain, their claim is against the property. So when we read the statute that says a claim under the owner, meaning, in other words, you could read it as the claim, you're assigned ownership rights that the original owner had.
But,
By some means.
but their claim right now is not on the property. They have to execute on the property if they want to say they have the right to execute
Because
on
they
it.
just have a general judgment lien, they don't have specific lien as this property.
That is correct, Your Honor. And
This isn't a
so,
mortgage,
Right.
this really isn't even a lien as to this specific property, it's just a general judgment.
that's correct. That's created a cloud on the title, and you know, go try to go sell that, and you've got a cloud you can't get rid of. And so for the county to turn that into money, they're going to have to do something. They want to attach it to this piece of property, they're going to have to take action. And we're saying, the judge was right to find that that action's too late now, and they knew it. You can't claim that you're entitled to the protections of being the county under 197.552, but then you're not subject to the other statute that expressly refers to the tax deed statute. So 95.192 sub 1.
And so I'm gonna ask and answer the question that, you know, I was gonna make a specific general question, point and ask you to address it, and that is, the specific is, it says, except that a lien of record held by a county shall survive, but you're gonna tell me that it only survives the issuance. And that, yes, it survived, but then the 4-year clock is ticking.
That's correct, Your Honor, because
And then counsel for the county is gonna stand up and tell me why she thinks that's wrong.
yeah, because these two statutes refer to each other. Well, not refer to each other, but 95.1921 refers expressly to 197.552. You gotta read them together. You can give effect to both of them. You can make sense.
I'm sorry to interrupt.
No, no.
We're getting to the end of the time, and I really want to know, did anybody cite any cases where this 95.192 extinguished a lien on property that was sold pursuant to a tax deed? I mean, is there any authority for that? I didn't find any when I looked.
Your Honor, I have no recollection of any in our trial court record. I, of course, came into the case later, but, you know, I've gone through the record, and I don't think either side had any case
And I
law
don't
on
recall
that
either
point.
brief citing anything.
But there's no lien on this property.
That's correct. There is no lien on this property, and we're back to that whole point,
Right.
that if the county wants to make it a lien, go for it. And then we're gonna say, you're out of time. You're way past your 4 years. You can't say you didn't get this judgment from the former owner or against.
But you're aligning Judge Kelly's other point that it's well, I mean, leaving aside, presuming that that an action is not merely against the tax deed, challenging the validity of the tax deed or something like that. It's any action based on the property that subjects the deed, you're saying.
I'm saying that,
No action shall be brought, and the action, maybe Judge Kelly can correct me, I might have botched your point.
No, I think it's pretty good.
But, you know, you're saying, no action, this is not an action against the tax deed that the accountant would be, right? It's just an action, it's just trying to foreclose on property subject to that they're eventually will be subject to lien, right?
well, it could be theoretically subject to a lien if they could go through the execution and get it attached.
But your roadblock is a bar on actions, and Judge Kelly's raised the question, what type of actions are barred?
Well, if it's,
Is this just a statute for closing actions challenging the tax deeds itself?
this 95.192 doesn't really suggest that it's limited. I mean, the tax deed conveys all the rights to the property that a regular deed does, right? Except you gotta
It's actually a brand new root of title.
Yep.
Sort of
sort of a
the
fresh
old
start,
days. Yeah.
fresh start.
Well,
Clean slate.
Ms. Mossy, you are at the end of your time. I actually gave you a little bit extra because of all our questions. So if you'd like to wrap up, please.
Thank you, Your Honor. We think that the trial judge got this case correctly resolved for any of the reasons that we were just discussing. I know it's a little complex, but when you boil it down to the basics, I think it makes logical sense how the trial court got there. If for any reason you all disagree with me, there's still an issue pending that never got resolved, which was our client's claim to have a first right to be reimbursed for all the money they've spent on the tax deeds and maintenance of the property. But, you know, we don't think we have to get there. So, thank you so much.
All right, now, to be fair, I'm going to give you 3 minutes.
Thank you. I want to start by, I think, clarifying the issue with the foreclosure. When I was discussing the foreclosure, it was my understanding that the question was talking about, would that be an action that would trigger this statute? And yes, I agree that foreclosure would be an action. My point that I was really trying to get across is just that this statute is inapplicable in this case because the county has not brought an action for foreclosure. We're merely arguing that our lien has continued to attach pursuant to law.
And I think the county's position is it's never gonna do that. right?
I
We just wanna
don't-
keep our lien.
I don't think that the county would do that. The county had the opportunity to foreclose on this property previously and elected not to do so. At this point, the argument is just that.
That was a stretcher for me. I'll just be honest.
I was not part of the
Is there anything in the
decision.
record? Why? What?
I was not in the room.
They don't turn this into specifically on real property. Nothing is done on what I'm sure was probably a single asset entity. Maybe not, I don't know, but I mean, I can't imagine why.
And I'm unaware, there's nothing in the record that tells us why the
Okay,
decision was made.
okay.
But just from where we stand today, that was the point that, hey, when you look at the statute, right off the bat, it's not applicable because there hasn't been an action. And then the secondary argument that the county is also not a claimant under the former owner.
But, so to clarify, you're
Yeah.
saying, you're conceding my point, or, is backing in the corner, and you said, yes, that if you conceded that that they're an owner of the claimant, then yes, the foreclosure action would be foreclosed.
Right, but that would.
You're saying that
Yes.
that they actually could foreclose on the lien, and they could bring an action on the lien because they're not an owner or a claimant under the former.
Yes.
So to explain to us what, that distinction, in other words, why having their interest, what does that mean, under the former owner? A claimant under the former owner. So a former owner cannot bring an action. We don't know what kind of action it is, that's up in the air. But also a claimant under the former owner.
Yes, and when you look at the context of the statute, when it's talking about the adverse possession, limitations upon acting against deeds, the subsections of the statute talk about ownership and possession. So the way that I'm interpreting this, and my client interprets this, is that it would be a claimant under the former owner, like you said, that would have an assignment of rights or some kind of interest in the actual ownership of the property itself. Whether that's, okay, sorry.
Yeah, I'm sorry.
Okay. Well, and again, though, the county hasn't brought a claim against Crest Capital. There hasn't been a claim made or an action brought. Would the court like me to touch on the first priority equitable lien argument that was referenced?
Well, why, if we reverse, why would we resolve that? Why wouldn't we allow the trial court?
Well, Your Honor, there was no holding on that. There was no oral argument made at the hearing, so we don't have a determination in the final judgment. However, it was.
No, we have to remand it, right?
Well, I thought your point was that we should tell the trial court not to bother.
Well, it was already brought up and dismissed in a former motion for summary judgment. And my point to the court was that there was briefing done on this for the motion. It just wasn't orally argued. So the county has addressed it. So it's within the record.
So you're saying we can tie it all on a bow and tell the trial court, enter summary judgment in favor of Pinellas County on a whole enchilada, and don't worry about this other alternative argument.
Well, Your Honor, I would love for that to happen, but I'm not sure if that's the case. But I wanted to bring it to the court's attention because there was this argument made and briefed it in here for you as to why the county.
And we're gonna have to leave it there.
Okay.
Thank you very much. Thank you
you.
both for this really interesting case. Our only case for today, you made it worthwhile.